this final hearing for the first AL Cancun bis Pre-Moot. Welcome everybody. Welcome to the arbitrators, to the teams that will be participating, and to everybody in the audience. So before we start, I would like to introduce my co-arbitrators, Dr. Ajar Rab and Madam Catherine Rogers. Let me give you a very short curricular semblance of the arbitrators. Catherine Rogers is a professor of law at Bocconi University in Milan, Italy. Her scholarship focuses on the convergence of the public and private in international adjudication and the intersection of markets and regulation of professional conduct in international arbitration. Professor Rogers is a reporter for the American Law Institute Restatement of the U.S. Law of International, Commercial, and Investor State Arbitration. Among her research projects, Professor Rogers co-chaired the ICCA Queen Mary Task Force on Third-Party Funding in International Arbitration and was a member of the IBA Task Force on Guidelines regarding Party Representatives in International Arbitration. She authored the monograph Ethics in International Arbitration and dozens of articles and book chapters on topics relating to the ethical responsibilities of arbitrators, counsel, and other actors in international arbitration. Professor Rogers is also the founder of Arbitrator Intelligence, a nonprofit turned legal tech startup that aims to make arbitrator selection more fair, predictable, and transparent. Thank you so much, Catherine, for being here with us.
My pleasure. Thank you.
Now, Dr. Ararjab is a founding partner at A&R Law LLP, the Handren, and an arbitrator. His practice areas include international arbitration, corporate transactions, and commercial litigation. He handles several arbitrations and commercial litigations relating to energy disputes, EPC contracts, infrastructure disputes, amongst others. He has previously worked with ministries, government bodies, and policy institutes. He is also an international policy consultant at Lexidale. Dr. Rab is a professor of practice at the School of Law, University of Petroleum and Energy Studies, Dehradun, distinguished visiting professor at National University of Juridical Sciences, Calcutta, visiting professor at National Law School of India University, Bangalore, and visiting faculty in other law schools of the country. He is a nominated member of the Board of Studies, Nirma University, as well as Tamil Nadu National Law University. He frequently trains executives and legal teams of multinational corporations, civil servants, and teaches courses on negotiation and drafting of commercial documents, litigation strategy, and international commercial arbitration at various law universities in India. He is also a member of several arbitration institutes across the world, a member of the advisory board, as well as on the peer review board of several academic journals. He has authored books on interim measures in international commercial arbitration, a comparative review, and Real Estate Regulation and Development Act, 2016, and Drafting of Contracts, EBC. He has published several academic papers in leading national and international journals, and his paper, Defining the Contours of Public Policy Exception, a new test for arbitrability in India, was cited by a full bench of the Supreme Court in India in Vidya Drolia and others versus Druga Trading Corporation 2020. Thank you so much, Ajar, for being here with us.
Thank you, Luis, and sorry to tire you out with that introduction.
No, it's a brief introduction considering your career. I would like to introduce myself. My name is Luis Alberto King. I'm a Mexican attorney. I now head the legal boutique called Anchor Legal, and I have been coaching moots for many years. And now I'm the organizer, or a member of the organizing committee of this first AL Cancun bis Pre-Moot. I would like to introduce the teams. First, acting as claimant, NLS Bangalore, represented here by Shruti Jain and Ananya Tangri. Ananya Tangri. And for the respondent, Universidad Francisco Marroquín, represented here by Andrea Calvillo and Michelle Rendon. Welcome. So let's commence the hearing. And I would ask the parties to please introduce themselves and let us know if there's an agreement or a proposal regarding the conduction, the order of the procedure, and the time allocation for each speaker. Counsel for claimant?
Luis, just before that,
Yes,
respondent, just in the interest of fairness, I am an alumnus of National Law School Bangalore, the claimant university, and have taught courses there, but I have not coached this team in any manner, and I don't know them personally either. I hope that's okay with you in terms of a conflict. Yes? All right. Thank you so much.
Thank you, Ajar. So, counsel for claimant?
Greetings, greetings, members of the tribunal. I am Shruti, and along with my co-counsel Ananya, we'll be representing the claimant in these proceedings. We have not yet had a chance to decide on an order of speaking, but we would like to propose that the respondent proceed first on the jurisdiction issues, and then claimant on procedure, followed by claimant leading on merits, and then respondent on merits. All speakers can speak for 14 minutes submissions, reserving 1 minute for rebuttals and sur-rebuttals, if that is fine with the other team.
Counsel for respondent?
Good evening, members of the Arbitral Tribunal, esteemed colleagues. My name is Michelle Rendon, and together with my co-counsel, Andrea Calvillo, we represent respondent in the present proceedings. As respondent, we agree both with the order and the time allocation proposed by counsel for claimant.
Very well. So, any procedural matters that we have to resolve before we commence? I would ask my co-arbitrators. Nothing. Thank you.
Nothing from me.
Very well. So now, unless the parties have anything else at this point, the floor goes to Ms. Calvillo for the presentation on procedural issues by respondent. So Ms. Calvillo, go ahead whenever you're ready.
Good evening, members of the Arbitral Tribunal, esteemed colleagues. My name is Andrea Calvillo, and today, with my co-counsel, Michelle Rendon, we appear on behalf of respondent, Equatoriana Geoscience Ltd. in the present dispute. I will be addressing for the next 14 minutes the two issues of procedure, being those first, why the Arbitral Tribunal lacks jurisdiction over the present dispute, and second, why the proceedings should be stayed or, alternatively, bifurcated. Regarding my first submission, the Arbitral Tribunal lacks jurisdiction over the present dispute. This issue is going to be divided in two main points. First, I will address why the arbitration agreement is invalid due to lack of respondent's capacity, and then I will determine why the arbitration agreement is invalid because it has been concluded through corruption. Regarding the first point, the arbitration agreement is invalid because respondent lack of capacity to validly conclude it. Members of the Arbitral Tribunal, constitutions usually provide certain requirements in order to render valid arbitration agreements for state-owned entities, and that is precisely what occurs in Equatoriana. According to Article 75 of Equatoriana's Constitution, when a party celebrates a contract with a state-owned entity, it is necessary to authorizations prior to the conclusion of a contract. First, an authorization by the Minister of Natural Resources and Development, and second, an authorization by the Parliament of Equatoriana. Nevertheless, the latter authorization was not granted prior to the conclusion of the PSA on December 1st,
Counsel, can I interrupt you just because I understand you're laying out for us the formal requirements, but it seems to me the question here is whether there are any instances when those formal requirements are no longer relevant or binding. In this instance, we had a formal delegation and a signing ceremony, as well as delay. And my question is, how do these facts affect what you are saying are constitutional prerequisites? And in particular, I'd like you to comment on whether there can be waiver by your government Whether it intends to or wants to have that waiver be effective or not is a different issue. But can your government legally waive in a way that's binding on it these obligations that you say are constitutionally required?
In order to answer your question, Madam Arbitrator, I want the arbitral tribunal follow me to page 12 of the record, which contain Article 20 of the PSA, that in the subsection D establishes that the agreement is governed by the law of Ecuadoriana. This means that this formal requirement, it is in the substantive law applicable to the validity of the arbitration agreement. That is why this requirement has to be fulfilled. And in regard, if there is a waive of something related to the acts of the parties, this arbitral tribunal has to take into account that this formal requirement is in order to have authority to render a valid agreement at that moment. So in the present case, we cannot take into account that it was a formal meeting regarding the conclusion of that contract, because at that time, the CEO of respondent does not have the power to render a valid agreement.
Counsel, just to understand this better, it is a private limited company, yes, and the CEO is signing. As a third party, wouldn't I be under the reasonable impression that the CEO would have the authority to sign this agreement?
For answer your question, Mr. Arbitrator, I would like that this arbitral tribunal follow me to page 18 of the record. In paragraph 6 and 7, you could see that Ms. Horatia Porter, which is part of the legal department of claimant, establishes that claimant knew that this requirement was necessary in order to render an agreement. So in a normal situation, a party could gain confidence in order that this agreement was signed. Nevertheless, that was not the situation with claimant, because they knew that this authorization was necessary in order to render a valid agreement. That is why this arbitral tribunal has to consider that this agreement is invalid. Regarding the second point, the arbitration
Counsel,
agreement...
excuse me, I'm sorry to interrupt, but I think you failed to answer the question of my co-arbitrator, Madam Catherine Rogers, particularly on the case that may this authorization be waived. I mean, may these requirements be waived at any point?
In the present case, this authorization was never waived by respondent by any motion, and this authorization was still necessary in order to render a valid agreement. Because there is a constitutional, yes.
Sorry, I didn't mean to speak over you. I think there's a slight delay. I'm across the world in Italy, so apologies for that. But I guess I'm a little troubled, because it seems to me that if you, from your position, because it says in your law that these signatures are required, that your client could, in entering this contract, essentially tell the other side, yes, it's in our law, but don't worry, you know, it's not really enforced. And so let's have this huge signing ceremony with an official delegation, and then essentially pull the rug out from under them and say, oh, that was all, you know, all for naught, because in fact, it's not valid. I mean, at what point is it fair to the other side, when you've gone through all of this ceremony and made representations, to say, oh no, we're still bound by that law?
I understand your concern, Madam Arbitrator. Nevertheless, in the present case, we have to take into account that the underlying contract, which is the PSA, could validly be concluded on December 1st, 2020. And precisely that contract has a valid agreement itself by the authorization by the Minister of Natural Resources and Development. Nevertheless, since the lack of authorization by the Parliament of Ecuadoriana was not granted, the arbitration agreement does not have that validity that the PSA have at that moment. So that is why in the present case, respondent can submit that in the present case, according to the law of Ecuadoriana, there is a lack of capacity for respondent to conclude a valid arbitration agreement.
Counsel,
in the present case, also the arbitration agreement is...
Can you hear me? Yeah,
yes,
all right.
yes.
I'm sorry to cut you short, but you took us to page 12, which talks about The agreement is governed by the law of Equatoriana. So the entire submission so far is premised on this arbitral tribunal applying the governing law to the arbitration agreement itself. Am I right?
That's
What
right.
what if we decide to apply the substantive law of the seat to this issue, and at that point, in effect, uphold the validation principle? So what you have to really tell us is, A, that this requirement is so fundamental that it would constitute mandatory law and we cannot disregard it. And two, despite the ceremony, there can be no waiver, because even by consent, we cannot confer jurisdiction. Would you agree with that position? Because your entire premise so far is based on an assumption that we're going to apply the law of Equatoriana to the arbitration agreement.
In the present case, Mr. Arbitrator, I will have to disagree with you in the present case, because given that having stated in the Sudamerica case or in Capicho, where the parties expressly choose a provision for law, then we have to determine that it's an implied choice of law. And in this regard, precisely the parties, the law applicable to both the arbitration and the underlying contract was the law of Equatoriana. And that is precisely what this arbitral tribunal has to determine, that since the law applicable to apply the substantive validity of the arbitration clause is the law of Equatoriana, then this arbitration agreement is invalid. Regarding to the second point, the arbitration agreement is also invalid because it has been concluded through corruption. Members of the arbitral tribunal, even when the underlying contract and the arbitration agreement are separable agreements, this does not mean that they are separate. In this regard, as has been stated by the tribunal in the ICC case 7401, when the invalidity of the main agreement and the arbitration clause defect on the same thing, we have to consider that both are invalid. That is precisely what occurs in the present case. There are two main indications that this arbitral tribunal has to take into account in order to consider that the PSA and the arbitration agreement have both been concluded through corruption. Regarding the first point, the call for tender determines that no party that has a link to corruption can be a valid bidder. In this regard, if the members of the arbitral tribunal could kindly follow me to page 44 of the record. In paragraph 3, you could see that claimant has had two previous incidents which have a link to corruption. In this regard, in the first place,
are you essentially are you asking us to assume your conclusion that there has been corruption before there's actually been proof of corruption, and to impose consequences for corruption that you've alleged but haven't proven, and you want us to essentially apply that as treat it as a proven fact?
In the present case, Madam Arbitrator, respondent's submission is that given that the alleged corruption has to be proved, that is precisely why the proceedings should be stayed in the future, or alternatively be bifurcated, because it's matter of this arbitral tribunal to determine by the proof itself that there is a corruption regarding the validity of the arbitration agreement. This gives me to my second point, why this arbitral tribunal should state, or alternatively...
Counsel.
Sorry, go ahead.
Please. No, go ahead.
The only question that I wanted to ask is, if we decide that we don't have jurisdiction, what happens? What is the remedy to the claimant? Because that's going to be an important factor in determining whether the lack of jurisdiction is going to cause further prejudice to the claimant.
Sorry, Mr. Arbitrator, could you rephrase me your question, please?
Yes, the question is simply, okay, we grant your prayer, we don't have jurisdiction. Where does the claimant go to redress its grievance?
In the present case, it will be in the courts of Equatoriana itself.
So you want the claimant to come to your court, right?
In the case
In a hostile jurisdiction, in a corruption scandal, to be picked up before the claimant even reaches the court. Is that why you want to oppose jurisdiction after a grand ceremony?
I understand your concern, Mr. Arbitrator. Nevertheless, it is respondent's submission that given that the arbitration agreement is invalid, this arbitral tribunal does not have jurisdiction, and in the present case, the courts of Ecuadoriana has the closest connection to the performance of the contract. So precisely, it will be the courts of Ecuadoriana will have the jurisdiction of that claim in a specific. Regarding the
Counsel, before you move on, let me just ask you a question. So I understand the issue in contention here is not really the validity of the arbitration agreement, but if the tribunal has jurisdiction over respondent, right? Over this case.
Yes.
So just to be clear here, so this is something, and I think Madam Rogers made a question pointing to what I'm going to ask you. So there were certain activities. There was a signing ceremony, and what the minister at that point said, what the representatives of respondent at that point said was it was merely a formality, and they were going to comply with it. This was part of the signing, something that they had to do to give effect to the contract. Just the same as giving effect to orders to pay the price and to receive the goods, which they didn't do. So aren't we seeing here a non-compliance of respondents on the terms?
In order to answer your question, Mr. Chairman, I will kindly ask this arbitral tribunal 1 extra minute in order to answer and final my submission.
We'll have to take into consideration how much time we take into in your presentation, because we haven't heard about the second submission. So we are up to 14, almost 15 minutes. I'm taking into consideration, and a similar extension will be given to claimant. But for now, please answer the questions.
Okay. Precisely, in the present case, given that there was a formal event in order to conclude the agreement, and that the contract was already started to perform, this does not mean that it could be a demonstration of comply with the capacity issues regarding the arbitration clause. And also, this does not mean that the corruption issue does not taint the arbitration agreement itself.
But the thing that I'm asking you, Counsel, is respondent failed to comply. They didn't pay, they didn't accept. You're talking about performance. I cannot see where the performance of respondent is. So they said, we're going to comply with this formality, and they didn't. So it's interesting that you're asking us to consider the non-compliance of respondent in the prejudice of claimant. It's going to affect claimant's rights, not respondent. How can this be?
Regarding the point of the moratorium itself, it has to be taken into consideration by this arbitral tribunal that the respondent is a state-owned entity that not have the power to perform a contract that has a link to corruption as per the Ecuadorian law. And that is why they stopped to perform. Nevertheless, they already paid $10 million in order to perform this contract. So precisely, the good faith of respondent was to comply with this contract. Nevertheless, since it has corruption issues regarding it, it has not been a possible solution to still complying with those obligations prior to the determination of the courts of Ecuadoriana relying to the corruption issues.
So let me jump in a little bit further in your presentation to the stay or bifurcation. You were already talking about it, and now you're talking about the corruption. So if we know, and this is part of your argument, your first argument, there is corruption. We don't know the extent of the corruption, but we know that it was corruption. And now you posited a moment ago in response to my co-arbitrator's, Dr. Ajar Rab's question, that the claimant should go to court. So wouldn't we be negligent in protecting claimants' sphere of rights if we know there's corruption in the government and we declare that we don't have jurisdiction? Bear in mind, in connection with the stay of the procedure, you're going to ask me in a minute that it should be stayed until the investigations are concluded, correct?
Right.
The investigations are going to be done by request of this government that, as we know now and you have accepted, has issues of corruption. So what should we do here? Should we trust the corrupt government?
In the present case, I first has to address that given that the corruption issues exist, these only are related to the executive power in the government and not the jurisdictional power. So in the present case, we have to consider that
that we know of.
Precisely, that's correct. That's correct. So in the present case, given that this arbitral tribunal has to take into account that in order to have jurisdiction, there should be a valid agreement, then they have to also address the issues of corruption.
Council, I'm sorry to interrupt you again, but so I forgot a question that I wanted to ask you. So the validity of the agreement. So as I said, the issue is, do we have jurisdiction, not the validity. Your argument centers on the validity, but the contention is whether we have jurisdiction or not. So there's similar cases where there's not an agreement to bind parties into arbitration. This is non-signatories. So if we consider, this is what I'm thinking, and I want you to opine on my logic. So if we consider that there is no arbitration agreement, but as you said, through performance, negotiation, and the appearance of actually acting as one of the parties, we could consider that respondent bound itself through conduct, through the many theories of non-signatories, and it should be bound, and then we do have jurisdiction on an alternative theory. What is your opinion on this?
Regarding that point in specific, if there is no valid arbitration agreement between signatory parties, then the arbitral tribunal has not jurisdiction over the dispute itself. Nevertheless, in the case of third parties, we have to take into account that they are in relationship, for example, for the doctrine of group of companies or peers of the Bell Corporative situation. So, but it is not the present case itself. It
would be a reverse economic stoppage.
In the present case, respondent submission is that given that Article 23 of the PCA rules determine that the jurisdiction of the arbitral tribunal includes taking the question about the validity of the arbitration agreement itself, and also Article 16 of Ecuadorian's Constitution of the law of Danubia, and reference that this situation has to take into account as the validity of the arbitration clause, then this arbitral tribunal should determine that they lack jurisdiction because there is no valid arbitration agreement.
Okay, thank you, Council. Please, we're up to 21 minutes, so please wrap up your presentation of the second issue regarding the stay and bifurcation.
Yes, thank you. Regarding the second point, this arbitral tribunal should state or alternatively bifurcate the proceedings. This is so because in the present case, it is necessary in order to render a valid solution regarding the validity issues of the arbitration agreement that this arbitral tribunal takes into account the documents that are going to be relying in the Ecuadorianos courts about the investigation issues regarding Mr. Phil, which was the COO of respondent at the time of the conclusion of the contract. Given that this authorization was not met at the time of the conclusion of the contract, and also that was corruption issues regarding the arbitration clause, this arbitral tribunal has to determine that is linked to the present dispute, and in order to render a valid award, you have to take those documents into account. Nevertheless, if this arbitral tribunal does not consider that state the proceedings should be the best solution, you could bifurcate it and wait to first know the two issues regarding the law applicable, and after the issue of the validity of the arbitration clause. If there are no further questions, this will end respondent's submission.
I just have a question, a quick question. So have you considered the effect that it would have on claimant? I mean, So we're thinking about rendering an award, of course. So have you considered that if the investigations turn out, the result of the investigations is that there was no corruption or not a corruption that affects this contract, what would be the effect of the damage that would cause to claimant, particularly considering then claimant would have to enforce this award in the country of your client?
Precisely in the present case, it is important to take into account that the place where the award is going to be enforced is Ecuatoriana. And if these provisions does not take into account the corruption issues and also the issues regarding to the validity of the arbitration agreement itself, then it could be an enforceable award. In the present case, claimant does not have a material prejudice because they already have 10 million euros from Ecuatoriana Geoscience Ltd. So, independent of the proceedings, we will determine that if there is a valid arbitration agreement and if there is a valid contract, that respondent will be bind to conform himself if this arbitral tribunal determine.
Very well. So this concludes your presentation, Counsel?
Yes, this concludes my presentation. Thank you so much.
My co-arbitrators, any further questions? Thank you. So that's 24 minutes and 11 seconds. Counsel for claimant will have a similar extension of time, although I do ask you that if possible, try to keep it as short, as you can. So Ms. Shruti Jain, please, the floor is yours.
Greetings, members of the tribunal. I am Shruti, and along with my co-counsel, Ms. Ananya, I will be representing the claimant Drone PLC in these proceedings. The present dispute represents the classic case of a state entity invoking its own mistakes under its domestic law to dispute this tribunal's jurisdiction. Members of the tribunal.
Excuse me, I'm sorry, when you characterize it as their own mistakes, I just have a little concern about that, because it sounds to me like there was a clear statement to your party that there was a formal requirement of approval, that at no time did they misrepresent that approval had been obtained. And so your client was on notice that in fact the requirements had not been satisfied.
Madam Arbitrator, while our client was aware of Article 75 of the Ecuadorian Constitution, it is our submission here today that because Danubian law governs this arbitration agreement, no reliance can be placed on Ecuadorian law to now dispute this tribunal's jurisdiction. Further, even though we were aware of the requirement, the minister did represent to us that it was only a formality. And therefore,
but since when do only formalities not count? I mean, a signature on a contract is only a formality, but you say that, you should be able to sort of ignore formalities when it's convenient for your client?
Members of the tribunal, if I could direct your attention to page 35 of the record.
I'm sorry, page what, Counsel?
35.
35.
Is the tribunal with me? In the first few lines of this email, Mr. Bluntschli has said that he is glad to hear that the minister does not consider the cancellation of the parliamentary debate and decision to be an obstacle to his approval of the agreement, and that the signing procedure can proceed as planned. This shows that the minister did represent to claimant that the lack of parliamentary approval posed no hindrance to the signing of the agreement, and the official signing procedure did proceed as it was planned.
But the representation, sorry.
No, go ahead, Catherine, go ahead.
But the representation wasn't that that the formality had been waived. It was only that the signing could go forward. And they knew that for the signing to be effective, it required this formality to be completed. So are you contending that by saying that the signing could go forward, that we should interpret that as a waiver of the approval process?
Madam Arbitrator, we need not consider that as a waiver of the approval process. However, this does raise some questions about the responsibility on respondent here. And I have two submissions to make in this regard. First, that since Danubian law governs this arbitration agreement, Equatorian law cannot be invoked to dispute this tribunal's jurisdiction. And second, even under Equatorian law, respondent cannot invoke Article 75 of their Equatorian constitution to dispute this jurisdiction. To begin with my first argument, we submit that the parties have actually impliedly chosen Danubian law as the law governing the arbitration agreement, contrary to what respondent has argued. Respondent has argued that Article 20D, choosing the law of Equatoriana for the agreement, constitutes an implied choice of law for the arbitration agreement. However, they failed to account for the validation principle. The validation principle dictates that the parties should be presumed to have intended that their arbitration agreement will be governed by the law that validates it. The parties' agreement to settle disputes under the PCA and their choice of seat in a neutral country is a clear indication that they wish to detach the arbitration agreement from the domestic law of either party. Article 20D was meant to be the governing law for the main contract. However, it is not an implied choice of law for the arbitration agreement.
How do we decide to apply the validation principle just because we like it? I mean, it's I don't know where it's how that becomes applicable here.
Madam Arbitrator, in cases such as Enka versus Chubb, the validation principle has been recognized and also been widely recognized by commentators like Professor Gary Bond. And
Well, I'm not disputing that it's been recognized. What I'm asking is what is the basis for its recognition in the other case that you just mentioned? And I know that, of course, Professor Bourne likes this validation principle, but it's in part because his law firm essentially makes money from arbitration. So the more arbitration agreements that are upheld, of course, it's sort of in his business interest. But what source directs us to apply the validation principle, not some general idea that we like arbitration? And the case you mentioned, as far as I know, is not binding on us in any way.
Yes, Madam Arbitrator. The underlying logic behind the validation principle is that parties should be presumed to have intended that their agreement will be governed by the law that validates it. This is especially in light of the fact that they have not explicitly chosen a choice of law for the arbitration agreement specifically. Therefore, when the tribunal is undertaking this exercise of seeing what implied choice they have made, the validation principle has to be taken into account, as Equatorian law could potentially pose a substantial risk to the agreement's validity.
Counsel, I think you're slightly misdirected in what my co-arbitrator is really asking. Number one, the validation principle is also a rebuttable presumption, right? It's not gospel truth. So what you have to show is from the record that this case, in fact, merits application of that principle because the intent of the parties is unequivocally clear that there is an arbitration agreement. And as you answer that question, I would pose the same question I posed to your other counsel. If there is no jurisdiction in law, can a grand opening ceremony or even waiver for that matter, or even the signing of an agreement confer jurisdiction on a tribunal when the law states otherwise?
Thank you for your questions, Mr. Arbitrator. To address your first question, it is our submission that the parties' agreement to settle disputes before the PCA arbitral institution and their choice of seat in a neutral country is a clear indication that they wish to detach this arbitration agreement from the domestic law of either party. And this was recognized in the case of Balkan Energy versus Ghana, where the parties had entered into an arbitration agreement, and it was held that because their choice of seat was also in a neutral country, and so that is an indicator that they did wish to detach the arbitration agreement from either party's domestic law. And therefore, that warrants an application of the validation principle in the present case. To address your second question,
Counsel, I'm sorry to interrupt the answering of the questions of Dr. Rab, but we still are missing the reason. Let me paraphrase the question that was asked by Madam Rogers. So the strict theory or the general theory of arbitration says you select the seat, you select the lex arbitri or lex arbitrae, or whatever you want to call it, the law applicable to the procedure. And we need a rule, we need a criteria, we need a reason to forego the general selection of the lex arbitri. And you're telling us there is this principle, and in other cases it has been applied and it has been recognized, but we agree. But why should we use it in this case if there's a selection of the seat? And I see no problem with the selection of the seat. And up to this point, you haven't given us a reason. So I'm sorry that I interrupted the presentation answering of the questions, but please give us the reason why we should use the validation principle instead of the general theory that when you select the seat, you select the lex arbitri.
Yes, Mr. Arbitrator. In the present case, the parties have not chosen a law specific to the arbitration agreement. Their choice of law clause is generally for the main agreement. Therefore, they have not actually chosen any law for the arbitration agreement in particular. And when there are multiple laws that could be applicable to the arbitration agreement, then the validation principle must be used to ensure that the party's intention to enter into that valid arbitration agreement is still upheld by this tribunal.
Okay.
Because
So you're saying, I'm sorry to interrupt again. So you're saying that there's certain pathology in this arbitration agreement.
could you rephrase? I did not catch that.
It wasn't a complete arbitration. So you would say, as claimant, the arbitration agreement that I'm bringing forward has deficiencies.
Mr. Arbitrator, this is not a deficiency per se. It does happen quite commonly that parties do not always choose a law governing the arbitration agreement specifically. So this is not categorized as a deficiency per se. However, there is a need for interpretation by this tribunal as to which law will govern.
So if there's no deficiency, why should we interpret?
Mr. Arbitrator, because there is also a lack of choice for the arbitration agreement in particular. Therefore,
so there's a deficiency.
There is a deficiency in a sense, but that deficiency does not hinder the arbitration agreement's applicability or validity in any other way. It only requires some interpretation by the tribunal as to which law will govern the arbitration agreement. If I may move forward to my second argument to address the claims of corruption.
Once again, I'm sorry. You were answering Dr. Rab's question. Please continue with the answer of that question.
Yes, sorry, I'd forgotten about that. Mr. Arbitrator, to answer your question, even if no jurisdiction is there by law, something like a signing procedure can stop respondent from raising these allegations of lacking jurisdiction at a later stage. So the principle of estoppel could continue to apply.
Are you saying we can confer jurisdiction on a tribunal based on an equitable presumption of estoppel?
Mr. Arbitrator, there is a principle of international public policy which has been grounded through principles of good faith and estoppel, that a state entity cannot invoke its domestic law to dispute an arbitration agreement's validity after it freely entered into it. And this principle is best illustrated by the case of Gatoil versus NIOC by the Paris Court of Appeals. In this case, an Iranian state entity argued that an arbitration agreement was void for want of parliamentary approval. The Iranian constitution, much like the constitution of Equatoriana, required parliamentary approval for submitting disputes with foreign parties to arbitration. However, the court rejected that argument, holding that international public policy prohibited the Iranian company from now trying to invoke its domestic law to withdraw from the arbitration.
But wasn't that, in that case, wasn't the law invoked without having been previously made known to the other contracting party? I mean, that seems to me to be the sort of equitable principle there. If you don't tell the other party that you have this legal requirement and you sign the contract without them knowing, and then when it comes to performance, you sort of pull this argument out that they've never heard it before, That seems to me to be a different principle than what we have here, which is your client was fully informed, was fully aware, and has acknowledged in correspondence that they understood there was a formal requirement that the contract would not be valid without parliamentary approval. So it's unlike the other one where the parliamentary approval, the other case you mentioned where the parliamentary approval was sort of sprung as a surprise, your client essentially accepted this prerequisite and now is trying to say we should disregard this prerequisite that your client was aware of.
Madam Arbitrator, our client was aware that Article 75 of the Equatorian Constitution posed this parliamentary assent requirement. However, after the minister's assurances that it was a mere formality, the claimant could not be said to be aware of the legal ramifications that it could have on this validity of this arbitration agreement. And the
But
logic
shouldn't it
behind
have, sorry, but it seems to me when someone says, oh, it's a mere formality. I mean, when I'm signing, I don't know, a mortgage agreement, they say, oh, it's a mere formality to get the final approval. I don't act like I can go spend money that I don't have because the contract's not valid without that formal approval. And the fact that it's a quote unquote mere formality doesn't change the necessity. And so it seems convenient for your client to essentially interpret mere formality as no longer required, but that's not what mere formality means. It means that it has to be, it's essentially an affirmation that it's a requirement. It's an assessment, an opinion by someone whose opinion is not binding, that it won't be difficult or that it'll kind of come through. But wasn't your client negligent at best in relying on what was a mere opinion by someone whose opinion was not binding in the situation?
Madam Arbitrator, I understand your concern. However, the minister was a representative of the government. Claimant cannot be said to be negligent in relying on his statements because he was the one signing the agreement and he was the one who was in charge from the government side to overlook this agreement. Further,
I'm not saying, pardon me, I did not say that you were negligent in relying on what he said. My question is whether you were negligent in overreading what he said. He did not say that the parliamentary approval was no longer required or that the contract would be valid without it. What he said was that parliamentary approval was a mere formality. In other words, it shouldn't be difficult to apply. But he was also talking about an event that was going to happen in the future. And as any of us, when we predict something in the future that we think is a virtual assurance, sometimes we're wrong. And so in other words, my concern is that your client was negligent in relying on his prediction of the future that turned out to be wrong, and that your client should now accept the consequences of that.
Madam Arbitrator, the principles that I have mentioned through that case also have the underlying logic that when it is the state entity that a foreign party is contracting with, the state entity does have the higher responsibility and burden of ensuring that the domestic requirements are fulfilled. And after that state entity has represented to claimant, assuring them that it is only a formality that would be that poses no hindrance to the agreement signing procedure, claimant these principles can still apply because that state entity had the higher responsibility of ensuring these things.
Counsel, this case that you rely on is from investment arbitration or commercial arbitration?
It is from commercial arbitration.
So it is similar in fact, since this is not an investment arbitration, you're certain of that?
Yes,
Because
Mr. Arbitrator.
if it's investment arbitration, the consideration would be very different.
Mr. Arbitrator, the present case is also one of commercial arbitration.
Yeah, no, I'm just double checking. The Iranian case that you're referring to is commercial arbitration, is it?
Yes.
All right. Please carry on.
I want to ask you regarding the higher responsibility. So let's say that I believe your argument and it was a higher responsibility of respondent to comply with this mere formality. But I'm impressed with how you opened your presentation and you said that own mistakes. So wouldn't it be a mistake to not take into consideration the precondition? This is, at the moment of the signing of the contract, the parties knew, they were informed that there was this requirement of the approval. Your client knew about it. It was a precondition. You know, before it happens, for the arbitration clause to be valid, there needs to be an approval. It didn't happen before, and then you were supposed to obtain it later, and it didn't happen either. So this precondition for the validity or the effect, let's say, of the arbitration agreement was never met. Nevertheless, your client did not seek, before they filed a claim in arbitration, to get this mere formality complied with. Isn't that a mistake?
Mr. Arbitrator, we submit that considering other facts, such as the respondent also amending the arbitration agreement, our claimant was under the reasonable reliance that the arbitration agreement was valid because
But
its
how does-
ratification.
I mean, if they want to change it, how does it mean that there was an approval? It's the precondition. So let's look into the precondition. You knew that something had to happen. Madam Rogers said this beautifully, predicting the future. So you knew, your client knew, that something had to happen for it to be arbitral jurisdiction. Nevertheless, they filed a claim in arbitration. And now you're saying, go over this theory of validation and use all these very limited and last resort theories to find something that your client didn't get, didn't fulfill a precondition.
Mr. Arbitrator, but it is again our submission that because this responsibility was on respondent and because of the multiple assurances from the minister, their amendment of the arbitration agreement, and so on, these facts indicated to claimant that there was no hindrance to the validity of the arbitration agreement whatsoever. And therefore, the respondent cannot now rely on that lack of approval to dispute this tribunal's jurisdiction.
I understand, and we should have an administrative procedure against the Congress or against the minister who signed without the proper approval or whatever. That's the effects of non-compliance for respondent. But the effect of non-compliance of respondent's obligations is that your client doesn't have a valid arbitration agreement to file a claim in arbitration. And so I stay with how you started your presentation, their own mistakes. So their own mistakes must be taken into consideration and some consequence must be. But the consequence now, the precondition for the arbitration agreement to have effect was not met. And once again, we get to the mistake. What's the effect of the mistake that your client committed?
Mr. Arbitrator, we submit that our client reasonably relied on the minister's representations as he was a representative of the government and the respondent's acts as amending the arbitration agreement and their other statements to my client. Therefore, we submit that even though this approval was not formally met, respondent cannot invoke that now to dispute the arbitration agreement's validity. To now move forward to the second, if I may move forward, I see that my time has run out.
It's okay, you're within time. You still have time. Three
Okay.
minutes.
Okay, thank you. To move forward to the next broad submission, that the arbitral proceedings should not be stayed or bifurcated. Respondent has argued that the tribunal should wait for the domestic determination and investigations to be concluded. However, we submit that the tribunal need not wait for any domestic investigations and must not rely on their findings. This is because these investigations may be politically motivated and the impartiality of the authorities involved is suspect. Ms. Fonseca was specially appointed to look into corruption in the NP development program. The bidder who lost the contract to claimant is her brother-in-law. She has also benefited from the allegations against Mr. Field, as his arrest resulted in the promotion of a future daughter-in-law. Respondent also.
Aren't those issues to be dealt with within the procedures of the internal procedures of the investigation into corruption? It seems to me you're asking us to assume corruption on the government's side based on what might be called red flags there, but you want us to ignore the red flags regarding corruption on your side. Moreover, it seems to me very aggressive for an arbitral tribunal to say we're going to plow ahead and make determinations that essentially ignore the potential that the government might decide, its investigation might determine and conclude that there was corruption, and that somehow our jurisdiction as an arbitral tribunal in the commercial matter, in a sense, should supersede a criminal investigation locally. That to me seems like a very aggressive act by an arbitral tribunal when a government entity is involved. And you want to say the government has a sort of added obligation to obtain approval, but then you want to take away the government's, in a sense, prerogative when it comes to investigating its own corruption. So I'm a little troubled by this argument in that it seems to one, ask us to make a very aggressive decision that would essentially interfere with the government organization, when instead, as an arbitral tribunal, we should perhaps have deference to that process.
Madam Arbitrator, it is our submission that this tribunal should not wait for the investigations to be concluded, as the impartiality of the authorities is suspect. And this does not pose an obstacle
Counsel,
to
hang
that.
on. Counsel, just 1 second. I don't think your co-counsel also laid out the standard that we should apply under Article 17 of the PCA rules to determine the stay or bifurcation. Please first tell us what is the standard this tribunal should use to consider whether to stay or not to stay. It's only then that you can get into the suspect or the circumspect of the authorities and their doubts. So tell us what in law should be the standard when the tribunal should effectively stay its jurisdiction.
Mr. Arbitrator, the arbitral tribunals only grant stays. A stay is only justified in exceptional circumstances when there is a compelling reason to grant a stay. It has been held in cases like IPOC Growth Fund versus Finance Group that a stay must be refused if a party is requesting it for difficulty in obtaining evidence, as there were also similar facts in that case where the party wanted the arbitral tribunal to grant a stay because of criminal investigations going on. However, this does not constitute a compelling reason for the grant of a stay of an arbitration proceeding.
Counsel,
And
if I turn your attention to Article 26, I think, of the PCA rules, I mean, you don't need to refer to it, I'll just tell it to you in short. What you're in effect asking is an anti-arbitration injunction, right, by means of this stay. And therefore, the criteria should be whether there is eminent prejudice to the arbitral process. Now, the question that we then have to decide is whether there is going to be more prejudice to the process by staying this proceeding or by going on with this proceeding. And how do you decide a commercial dispute without evidence, tainted by corruption, presumably misrepresentation and fraud, right? Even if we were to go ahead and grant your request and pass this award, will we not be unfair to the process and also render an award which most likely will be set aside because we didn't have sufficient evidence to determine the background of this contract?
Mr. Arbitrator, the arbitral tribunal does have powers to call for evidence and conduct a fact-finding hearings and bring in witnesses. Therefore, the arbitral tribunal can by itself adjudicate on the issue of corruption. It is our submission that waiting for the domestic investigations or relying on their findings would cause prejudice to claimant, because those investigating authorities' impartiality is very questionable. Further, this does not constitute a compelling reason for the grant of a stay, and we submit that the present case warrants immediate resolution to remedy the grave commercial and reputational harm being suffered by claimant. Claimant is at a commercial loss. It has no immediate clientele for the materials that have already been bought for respondents' purposes. The drones that have already been produced also cannot be resold to other buyers without considerable price reductions and difficulties. Claimant's reputation has also taken a hit in the trade circle due to the coverage of this dispute in industry journals. Therefore, we submit that a stay or bifurcation of proceedings would only exacerbate this harm being suffered by claimant. If I could request just 20 more seconds to conclude my submissions. Members of the tribunal, respondent is seeking to undermine its arbitration agreement simply because the government has changed hands in Equatoriana. Because of this, claimant should not be left up without recourse to arbitration, and we request this tribunal to dismiss the respondent's challenge to jurisdiction and decline their request for a stay or bifurcation of proceedings. That concludes my submissions. Thank you.
Any questions from my co-arbitrators? Nothing? Very well. That's 28 minutes and 2 seconds, Council. No. So let's go to the rebuttal from Ms. Calvillo. 1 minute, please.
Members of the arbitral tribunal, claimant want you to ignore that there is a lack of authorization, that there is corruption surrounding the arbitration agreement, and also that there are criminal proceedings in Ecuatoriana regarding Mr. Phil's responsibility that are linked primarily to the PCA and the arbitration agreement. Practically, they want you to resolve a case with no nuances about what was happened in the present case. That is why this arbitral tribunal has to determine that the arbitration agreement is invalid, and also that in order to render that decision, they should stay the proceedings or alternatively bifurcated.
Members of the tribunal, respondent has again brought up how there is apparently corruption surrounding the arbitration agreement. However, they have not raised a single allegation that is specific to the arbitration agreement in particular. They have to first allege and then show that the arbitration clause in itself was solely entered into because of corruption and fraud. That is the only way that they can overcome the principle of separability. However, the only fact that they pointed us to was that claimant has had a corruption has had a corruption practice in history. That is not evidence of corruption in the arbitration agreement in any way, and therefore this tribunal's jurisdiction cannot be affected by these allegations of corruption. Thank you.
Thank you, Council. So the tribunal will take into consideration the arguments regarding the procedure, but for now, we will hear the arguments on the merits. I believe it's Ananya Tangri, the turn. So please, Ananya, go ahead.
Greetings, members of the tribunal. The present dispute concerns a situation where respondent is trying to circumvent an international sales convention, which it is a contracting party to, in order to access more favorable remedies under its domestic contract law. Respondent insists on entirely avoiding this agreement merely because a change in the political scenario of Equatoriana has now made it unsuitable to its needs. We therefore have two submissions before the tribunal presently. First, that the agreement is governed by the CISG, and second, that respondent cannot rely on its domestic law, the Equatorianian ICCA, in order to avoid the agreement in the present case. Moving forward with my first submission, we submit that the agreement is governed by the CISG in the present case for two primary reasons. First, that the Kestrel drones are not aircraft under Article 2E of the CISG, and hence the agreement is not a contract for aircraft, which may be considered outside the scope of the CISG. And second, the parties did not opt out of the CISG under Article 6 of the Convention. Moving forward with my first point, under Article 2E, the Kestrel drones are not aircraft. Respondent in the response to the notice of arbitration has argued that the Kestrel drones are aircraft for two reasons. First, because they fall within the domestic definition of aircraft under the Aviation Safety Act of Equatoriana, and second, because they are subject to registration ordinarily in Equatoriana. Members of the tribunal, this argument carries no weight, primarily because a domestic definitional or registration requirement cannot be used to interpret terms of the CISG, particularly those terms that define. Yes, Madam Arbitrator.
I'm sorry, I didn't mean to interrupt you mid-sentence, but while we might not look to domestic law to interpret the CISG, wouldn't domestic law be relevant to understanding the intent of the respondent in entering into this agreement?
Madam Arbitrator, regarding the intention of the parties, it is our submission, which is our second argument under this broad submission, that the parties did not show a shared intention to opt out of the CISG. Article 6 of the CISG.
But counsel, your argument that they didn't agree to opt out of it has a starting assumption that it would apply, and that's why they have to opt out of it. If it was instead under Article 8, the subjective intent that should be knowable to your client because it is in their written law, okay, that respondent never intended for the CISG to apply, right, then they don't need a separate decision to opt out of it because in a sense it was never intended to apply.
Madam Arbitrator, given that Equatoriana is a party to the CISG, and it is quite clear that because the choice of law is the law of Equatoriana, and therefore the CISG automatically applies under Article 1A, it is presumed that
unless, but you're sort of assuming your conclusion here, right? The CISG applies if it's not aircraft. And how do we determine whether it's not aircraft? It seems to me we should look to the intent of the parties and what they understood at the time. And certainly one of the parties, in a manner that's available and understandable by your client, was, I think we can at least assume for the sake of this argument, that at least their argument is they had a clear understanding that this would not be governed by the CISG because it was aircraft. And so it seems to me we have to overcome this concern that the subjective intent knowable to your client under Article 8 of respondent was that the CISG would not apply because it was not aircraft. So you can't, in other words, assume your own conclusion that the CISG applies automatically because the CISG only applies if the subject matter of the dispute comes under that definition. And if we have understanding that the parties clearly intended it would not, because it does not meet the definition for the CISG to apply, isn't that at least an issue we have to consider before we get to the question of whether they opted out?
Madam Arbitrator, in order to interpret terms of the convention, CISG provides, or rather even mandates under Article 7.1, that the international character of the CISG must be looked at. It is not the intention of the parties that is looked at in order to interpret an international convention such as the CISG. Even though the CISG does provide for the principle of party autonomy and intention, this principle is embodied under Article 6 of the CISG. In order to interpret the very terms of the CISG, which determine the scope of its application, Article 7.1 needs to be looked at. Mr. Arbitrator. Yes.
Yeah, I have a concern. Can you turn to page 10? Claimant Exhibit C2.
Yes, Mr. Arbitrator.
In the fifth recital, right, the word aircraft is used. Whereas in the third recital, the word unmanned aerial systems is used, right? Thereafter, in this next recital, whereas the changes are reflected by a higher number, again, the word aircraft is used. Then in Article 3, subclause B, the word aircraft is used. If you are to get onto this question of what was intended by the parties, then very clearly there appears to be, from bare reading of this agreement, that originally an unmanned aerial system to collect relevant geological and geophysical data was what was contemplated. And at that point, it would not have fallen in the definition of aircraft. But whereas in the process of negotiations, the scope of the agreement was changed for possible additional use of aircrafts. And therefore, what was then subsequently contemplated was in fact a machine capable of carrying material, medicine, etc., which would in fact make it an aircraft, right? So I don't think there is an ambiguity here. What was ultimately agreed upon was an aircraft. And therefore, now, can you please answer this question in the light of the CISG?
Mr. Arbitrator, two responses to that. First of all, regarding the intention of the parties, under Article 6, the threshold to be met in order to show a shared intention of the parties to opt out of the convention, as already clarified, the definition of aircraft cannot take into account intention of the parties under the CISG because Article 7(1) needs to be looked at. However, respondent cannot argue that the inconsistent use of the word aircraft in the PSA by itself shows intention to opt out of the convention. This is because it was clearly held in the electricity meters case that the threshold to be met in order to show a shared intention to opt out of the convention is a clear and unambiguous agreement reached between the parties. Members of the tribunal, there was no discussion or correspondence between the parties regarding the applicability of the CISG, much less a shared intention to opt out of it. Moreover, the only way in which the CISG was actually looked at the time of negotiations was when the fundamental breach clause of the purchase and supply agreement was changed explicitly to mirror a provision of the CISG, which is Article 25 of the CISG. Therefore, while there was no intention to opt out of the convention or to exclude the applicability of the CISG, there are facts on record to show that the parties in fact encouraged the application of the CISG by entering into an agreement which mirrored a provision of the CISG.
Counsel, my problem with your submission is simply that you are relying on a lot of academic literature to go into the question of what was intended or not intended under the CISG. At least for me, I'm more concerned about what we are going to do in the present facts, right? And if you turn to page 36, the Aviation Safety Act says that if an unmanned aerial vehicle in overall length exceeds 90 centimeter, or if their payload is higher than 50 kgs. So there is a clear test given, and given that a registration requirement would arise, and there is sufficient jurisprudence to say if there is a registration requirement, the CISG chose to exclude aircrafts because of that subjective intention of registration. The parties don't need to expressly intend exclusion of the CISG when it is clear by the very wordings of the CISG that it cannot possibly apply if there is a registration requirement.
Mr. Arbitrator, the intention of the CISG drafters was to exclude aircraft because they were subject to varying registration requirements. Moreover, when the predecessor to the CISG, the ULIS, it had a specific provision regarding registration of aircrafts. It only excluded those aircraft that were subject to registration. This requirement was removed by the drafters of the CISG because they specifically wanted to respect the international character of the CISG and prevent tribunals from looking at the specific national law registration requirements in different varying cases. In fact, in the present case, even if the registration requirement is considered material, which would be going against the specific intention of the drafters of the convention, even if then the registration requirement is looked at, in the present case, there was no requirement to register the Kestrel drones because they were to be owned and operated by a state-owned entity, when the Article 10 of the Aviation Safety Act only has a registration requirement for those aircraft that are to be owned and operated by a private entity. To address your second...
Which is a private entity, except it's owned by the state. It is not a state entity, as in it's not the government doing it, right? It's not the police. It's a private entity at the end of the day.
Mr. Arbitrator, there have been past instances where those entities that are closely linked to the state, there have been no registration requirements in Equatoriana for such entities. In the present case, the company is entirely owned by the government. Moreover, the supervisory board is also composed of government officials. All the finances of the company, Equatoriana Geoscience, come entirely from the government. And for this reason, it is to be owned and operated by a state-owned entity, and a registration requirement will not apply in the present case.
So, counsel, we should just junk the whole idea of a separate legal entity in a private company simply because it's financed by the state.
Mr. Arbitrator, there is overwhelming presence of the state in the operation of this company.
I
in the
completely
financing
agree
of
with
this
you.
company.
I completely agree with you. That's exactly my question. So we should just junk the idea of a separate legal entity simply because there is overwhelming evidence of the state owning the entity.
No, Mr. Arbitrator, it's just that in the very functioning of the Equatoriana Geoscience, the state is very crucially involved. The state minister's signature is required for any kind of contracts that the government entity enters into. Moreover, Equatoriana Geoscience has been established under a statute in Equatoriana, and it has the specific intention of fulfilling a public purpose, which is to explore minerals and use them and use the data collected in order to exploit the mineral resources in Equatoriana.
All that we're trying to get at, counsel, is that your argument about whether it is not required to be registered is also subject to interpretation then. It's not as clear because we don't know if it's a state entity or not.
Mr. Arbitrator, it is our submission that there's no registration requirement in the present case. However, we also submit that a registration requirement is immaterial because the drafter specifically intended under Article 2E that specific national registration requirements must not be looked at, keeping in mind the international character of the CISG. I see that I'm running out of time, so if I may conclude my submissions.
Counsel, I believe we still have an issue to go, and I've been dying to ask you a question. So please continue, and you have more time.
Moving to the second issue before the tribunal.
So before you move to the second issue, so I just want to understand, because the last words that you said confused me. So the registration is also immaterial.
Yes, Mr. Arbitrator.
So we shouldn't look to the registration then?
No, Mr. Arbitrator, registration requirements specific to the contracting party should not be looked at. What should be looked at is an autonomous standard under the CISG, which
allow me to voice my concern. So what we have to, and I jump exactly where Madam Rogers left. So this implies the application of CISG. The argument to prove the application of CISG implies the application of CISG as an axiom, if you will. So we start with the application, and then we say we do not go out. But you're trying to get to the definition of what is aircraft, correct? And you say we should not look into registration. We should not see what the domestic definition is in Equatoriana. So it's interesting because at some point, as counsel for respondent said, if we don't have jurisdiction, you'll have to go to Equatoriana's court. And at some point, you'll have to deal with the definition of aircraft according to Equatoriana law. So I believe that this would be an issue, you're jumping a step, but okay. We won't look into the sources. But if we don't look into the sources of law, the definition that is set in Equatoriana, then we don't see the registration requirements in Equatoriana either. We cannot take consideration in the intentions of the parties, regardless of the fact that one of the parties is from Equatoriana. You discredit the Article 8, the interpretation based on the intention of one of the parties, let's say the party that called for tender, the one who was asking something, and according to Article 8.1, the contract or the goods should be interpreted according to what the person asking for the product was intending. So if we take into consideration, you're asking us not to look at Equatoriana anything, basically the definition of Equatoriana, and the registration requirements of Ecuatoriana. You're telling us that we should not take into consideration the intentions of the parties to determine what aircraft is. So my question is, what should we take into consideration then?
Two responses to that, Mr. Arbitrator. Even if the dispute is taken to the Equatorianian courts, CISG will still apply to the present dispute, and CISG's terms, that is aircraft, will still be interpreted according to its own underlying principles under Article 7.1. Moving forward to your concern regarding intention.
Why 7.1 and not 8?
Sorry, Mr. Arbitrator, could you rephrase that?
Yes, in the international character, I agree, I understand. But the intention of the parties is the element that interprets every single disposition of the CISG. And you're saying, no, don't look at the intention of respondent. Why?
Mr. Arbitrator, we're not saying that you don't look at the intention of the parties. We are saying that there exists no clear and unambiguous intention to opt out of the CISG. Furthermore, we're saying that the shared intention of the parties needs to be looked at, not their unilateral intention relating to the tender. In fact, the definition that we propose to the tribunal for aircraft, which is in line with international standards, does in fact look at the intention of the parties.
Okay.
That
So,
definition.
counsel, just bear in mind one element here. Your client is an expert in aircraft or UAVs, whereas respondent is not an expert. So what was the principle your co-counsel talked about, the closest responsibility, highest responsibility? Who had the highest responsibility to determine the definition of the good, and if it falls in or out of the applicable law? So wasn't it the responsibility of the expert to say, be careful, this could fall within the CISG or not?
Mr. Arbitrator, my client's company is not an expert on the interpretation of the CISG. This is not a question relating to the aviation industry or aircrafts in particular, as they may be interpreted in the aviation industry. This is a question relating to the interpretation of the convention, which Equatoriana is a contracting party to. Therefore, there is no disproportionate burden on claimant to clarify any terms in the agreement, and the tribunal must look within the CISG in order to interpret the convention itself.
So you believe that it's not in the best interest of your client to sign clear agreements?
We do believe it is in the best interests of all parties to sign
But it's not
agreements.
a responsibility.
Mr. Arbitrator, this is a clear agreement. It only requires interpretation in the present case. What requires interpretation in the present case, in fact, is the convention, not the agreement.
Okay.
Because
Let me just, I have another prong question here. So if we, as a tribunal, are trying to find the definition of aircraft, then we may take into consideration several elements, several. Within those elements are the intention of the parties, the text, the communications, and also reference to technical documents, technical studies, but also the sources of law within different legal systems. This would be all persuasive. So you're saying us, don't take a look into what Ecuatoriana, you said before, don't take a look at what Ecuatoriana has and the registration requirements and so on and so forth. So if we may take into consideration all of these elements, because there are sources of law in international private law, which is what we're doing right here, why shouldn't we come up with a definition based on the general usage?
Mr. Arbitrator, because we propose to you a definition that is in line with the specific mandate of Article 7.1, because it takes into account an international standard. We propose the transport purpose definition, under which an aerial vehicle will qualify as an aircraft if it was intended for the purpose of transporting people or cargo. This standard is logically preferable, and we present it to the tribunal for two reasons. Firstly, it relies on an already existing CISG standard, which has been borrowed by analogy from the ships cases, which is another exception under Article 2E. Therefore, this standard promotes legal certainty in the interpretation of the CISG, which is an underlying aim of the CISG. Furthermore, a similar transport criterion is used by the Aircraft Protocol of the Cape Town Treaty, which is an international convention regarding the interests created in aircraft. Therefore, this meets the standard of being international in character as well. In the present case, even though the Kestrel drones were capable of transporting goods, they were not intended for the purpose of transporting goods. And because to the tribunal, the intention of the parties seems so relevant in this matter, the intention of the parties we submit was aerial surveillance. And the Kestrel drones were specifically engineered to promote aerial surveillance in the present case. And the intention was not to transport goods in the present case. And therefore, the Kestrel drones are not aircraft under this transport standard. As I can see that I've run out of time, if I may take 30 seconds to conclude my submissions. Members of the tribunal, the respondent should not be allowed to circumvent the CISG, which is clearly applicable to the present case. And regarding the second issue, there is no case for fraud to be made on merits. And for this reason, they cannot rely on their domestic law when the CISG precludes domestic law under Article 7.2. And for this reason, they cannot avoid the contract under their domestic law as well. Therefore, we request the tribunal to find that CISG is applicable and domestic law cannot be relied upon to avoid the contract for fraud. Unless I may be of further assistance, that concludes my submissions.
Thank you, counsel. My co-arbitrators, any further questions? Nothing, very well. Okay, so now we go with counsel for respondent, Ms. Rendon. Please go ahead, the floor is yours.
Thank you, Mr. Presiding Arbitrator. Members of the Arbitral Tribunal, once again, good evening. My name is Michelle Rendon, and together with my co-counsel, Andrea Calvillo, we represent respondent in the present proceedings. For my part, I will be addressing the same two main issues raised by counsel for claimant in the same order, namely the law applicable to the PSA, and second, the fact that respondent can rely on the Equatorianian law for the claim of misrepresentation. Regarding the first issue, the law applicable to the PSA is Equatorianian law excluding the CISG. For this point, counsel for claimant raised two main issues. First, that the Kestrel 2010 are not aircraft in the sense of the CISG, and second, that the parties did not opt out of the CISG in accordance with Article 6. Regarding the first argument, it is respondent submission that the Kestrel 2010 are aircraft in the sense of Article 2 of the CISG. And for this matter, I would like to invite the Arbitral Tribunal, or rather, I would like to quote to the Arbitral Tribunal Article 2E of the CISG. It reads, "This convention does not apply to sales of ships, vessels, hovercraft, or aircraft." In this sense, when the drafters of the convention were considering what goods to exclude from the convention, they took into account what counsel for claimant has also raised, the Uniform Law on the International Sale of Goods, otherwise known as the ULIS. In this sense, that instrument also contained the same exclusions for the scope of application of that instrument, with the exception that that instrument had a requisite of only excluding ships, vessels, hovercraft, and aircraft that were subject to registration. When the drafters of the CISG were considering that specific exclusion, they reasoned that given that there is no uniformity around the world on registration rules and that in some countries aircraft are subject to registry while in others they are not, that they should scratch that specific part of the exclusion and in turn exclude all aircraft, regardless of whether they are subject to registry or not. Also, members of the arbitral tribunal, we agree with counsel for claimant that the CISG must be interpreted autonomously and with regard to its international character. In this sense, we cannot turn to the definition of the Equatorian Safety Act, for example, but rather what this arbitral tribunal should take into account in order to determine what an aircraft is to the CISG is the intention of the drafters in the 1970s. In this sense, members of the arbitral tribunal,
Counsel, how do we take into account the intent of the drafters when in the 1970s there were no such thing as drones?
Madam Arbitrator, I would have to disagree with you. In this sense, if we look as far back as World War I, we can see that both the United Kingdom and the United States used unmanned aerial vehicles for the purposes of the war. Throughout the years, this technology has been developed and is now known as drones. In this sense, it should be noted that all throughout history, the main purpose of unmanned aerial systems has been for the aid of states. And the Kestrel 2010 is precisely in that sense also used by a state in order to further their purposes. Therefore, we can see that in the 1970s, when the CISG was being drafted, the drafters did have that type of technology available to them and considered unmanned aerial systems also as aircraft.
And unmanned aerial systems were operative in the 1970s and known to the drafters of the CISG?
Yes, Madam Arbitrator, they were used both in World War I as well as in the Vietnam War. In this sense,
But
members
Counsel,
of the...
excuse
Yes.
me, but I mean, I agree with your that the drones existed, the unmanned aerial systems existed before and for the usage of war. But the concept of a drone as something that I can keep in my pocket and fly around my house was not the I mean, this is something that is relatively new. So the point here is not the definition of aircraft, of course, but the usage, the good has transformed in time, or the usage of certain good that may have existed, but it was not a commercial good. It was a good reserved for the usage of war or military use. But in this case, we're talking about something that entered the commercial realm and can be seen as a good in the sense of the CISG, a marketing or marketed good. So here is the intention of the drafters. The drafters didn't think about aircraft as something that could be, sold easily.
Certainly, Mr. Arbitrator, respondent's position is precisely in agreement with that idea. Smaller aircraft, or rather smaller drones, are not precisely what the drafters were thinking because that technology was not yet available to them. Nevertheless, if we look at the unmanned aerial vehicles that were used by states for military purposes in that time, it is comparable to this specific situation because it is a state-owned entity owned by a state using it for their state purposes, for the surveillance and for exploiting the northern part of Equatoriana. Therefore, we see that the unmanned aerial vehicles that were available to the drafters of the CISG have similarities and the same purpose as the Kestrel 2010. Therefore, we should also consider that the
Counsel,
Yes.
just to follow up on that. So I agree, the drafters and all this discussion. But when considering the scope of the CISG, should we take into consideration the intended purpose or the nature of the good? Because I can buy whatever good, what are the cases? Tulips, spoons, cars, tires, whatever good. And I can use it for non-commercial purposes. This doesn't take away the characteristic of being regulated or that the CISG would apply to it.
Mr. Arbitrator, it is respondent submission for that point that the members of the arbitral tribunal should only consider what the drafters considered at the time. And precisely, they did not intend for aircraft to be interpreted on the whim of the intention of the parties, but rather on their very nature, what goods can be used for.
Counsel,
Yes.
sorry, I'm cutting you short. Can you tell me, you were the entity which brought out the tender, am I right?
Yes.
What was the tender for?
It was to acquire unmanned aerial vehicles that would help
And that's it.
respondent.
That's it. It's your intention to acquire unmanned aerial vehicles, not aircrafts. Right? And then and this contract, I believe, was drafted by the respondents, if I'm not mistaken, the PSA.
Yes.
And contra pro frentem would apply, and we should give the benefit of doubt to the claimant. Why do we need to consider the history of the CISG at all? Your intention was to acquire a good which specifically falls within the CISG. An unmanned aerial vehicle is not excluded in 21E.
Certainly not, Mr. Arbitrator. However, if we look at the very language of the contract, and for this point, I would like to invite the arbitral tribunal to page 10 of the record.
Yes.
We can see that the terms unmanned aerial systems, unmanned aerial vehicles, and aircraft are used interchangeably. So it was never respondent's intention when drafting this contract to provide for a definition of the good, but rather
That's
just...
exactly my point. That's exactly my point. Contra pro frentem would go against you. You are the one who drafted this and left these ambiguities. How do you, I mean, your reliance on these ambiguities actually goes against you.
Not precisely, Mr. Arbitrator. And the main reason why that is the case is that in respondent's view, the Kestrel 2010 would always be in a continual movement, and therefore it would always be able to be comparable to aircraft. That is maybe perhaps why they decided to use unmanned aerial vehicle and aircraft interchangeably, because it was their intention, since they were thinking of drones and a product, a good that is able to fly and is able to transport things, to not apply the CISG, but only the commercial and contract law of Ecuatoriana, excluding the CISG. Members of the arbitral tribunal, it should also be considered
Counsel,
that...
sorry, just to take you to page 33, Exhibit R2, which is a statement by your own minister.
Yes, I'm there.
Right, the first paragraph on the right-hand side.
Mhm.
A drone which normally carries cameras or other surveillance equipment in its cargo compartment should also be able to transport urgently needed spare parts or medicine to remote areas of the northern part of Ecuatoriana. What I seem to understand is that you use an ordinary meaning of the word aircraft, and what the drafters of the CISG intended was an aircraft capable of carrying humans and their registration requirements. Would that be a fair interpretation? And therefore, your statement of the minister itself suggests that is not the kind of aircraft that this tender was for. And therefore, the CISG just applies.
Mr. Arbitrator, if we look at the records on the United Nations conference in the 1970s, we can see that one of the considerations that the various delegates had was that their national laws required the registry of aircraft not only for those aircraft that that could transport people, but also for those that serve the specific purpose of transporting goods. Therefore, we can see that the drafters were thinking of excluding all aircraft because they are capable of transporting things, just like the Kestrel I.
But that itself goes against your previous counsel's argument that this was only for a limited purpose of national interest on geosurveillance, etc., and not capable of transport of anything else. Right.
Mr. Arbitrator, could you rephrase that, please?
What I'm trying to get at is that, I mean, let's put it in a slightly broader perspective. You knew these are unmanned aerial vehicles. You knew they're not aircrafts. All that you're now trying to do is somehow wriggle out of your obligation, because you know that if the CISG were to apply, the claimant has the chances to succeed and win this claim. Right? Therefore, you are now trying to take us back to an intention which was never contemplated at the time of the tender or the PSA, that these would be aircrafts.
Not exactly, Mr. Arbitrator. Respondent submission relies more on the fact that the parties did choose the law of Equatoriana, and when respondent was drafting the contract, it was never their intention for the drones not to be taken as aircraft, precisely because they were asking for a good that is capable of transport. In this sense, members of the arbitral tribunal, I have noticed that I am running out of time. Could I ask for an additional minute to conclude?
Yes, but I have a question on applicable law. So I want to hear your argument on the further ends. So if CISG does not apply, then we apply the ICCA.
For the PSA, yes.
But if we're saying that the contract was, one of the arguments that you wielded a moment ago was that it was only for the purposes of the government and surveillance, and this makes it a administrative contract, and then the ICCA would not apply. It's not a commercial contract. That's what I'm trying to get at.
Mr. Arbitrator, I do understand your concern. However, to that, respondent submission is that it is not an administrative contract, but a commercial one. If we look at the fact that the drones are going to be used for a specific purpose for now, but later the findings that the Hawkeye or the Kestrel I 2010 allows for this state-owned entity to use are going to be able to be commercialized. Therefore, we can see that the Kestrel I 2010 is a good necessary for this state-owned entity to later commercialize. In that sense, this contract could also be considered as a commercial relationship.
Okay, so
Counsel,
then...
Sorry, Luis, just one question, just a clarification that I need. If it's not an administrative contract, then do you agree the parliamentary approval was not required?
No, Mr. Arbitrator, let me rephrase. What respondent submission is that the specific part of the sale and the acquisition of the drones is a commercial relationship. Nevertheless, all of the authorizations and the fact that this is a state-owned entity entering into an arbitration agreement with a foreign entity is an administrative requirement, and thus the arbitration agreement is still invalid for not complying with its formal requisites.
But then, counsel, so just continuing with this, so for now, it's not going to be a contract with commercial intent, but it will become, it will have commercial intent later.
No, Mr. Arbitrator. What I meant is that since this contract is necessary for respondent to later commercialize, that then this needs to be considered as a commercial contract.
If it's a commercial contract, then by definition, what is the subject matter of the contract are commercial goods.
Yes.
So then if we take criteria to find the definition of aircraft and taking into consideration everything that we have discussed, then we would see that the product of the subject matter of the contract is not an aircraft in the sense that the drafters consider it, but it's in a teleological way a good that will be subject to commerce. And this would go against the argument that you have been bringing forward for 18 minutes.
Mr. Arbitrator, I would have to disagree with you because the fact that there is a commercial relationship between two parties does not necessarily make the good sold under that contract a commercial good. In this sense, the Kestrel 2010 itself is not being commercialized. It is not being resold in the market for the purposes of respondent gaining money. Rather, what respondent submission is that the Kestrel 2010 will help respondent to acquire information on the northern part of Equatoriana, and that this information that the Kestrel provided later will help respondent to commercialize, to have a commercial activity. And in that sense, that specific part of the relationship between these parties is a commercial relationship.
So this will help the government further its own governmental efforts or interests. Yes?
In a sense, it could be that way, but it must be noted that as a state-owned entity, it is still a juridical person that usually engages in commerce and
So,
not
the-
the state
I
itself.
have a problem here because it's a company that's a state-owned, so it looks like a duck. Then the purposes of the purchase of the aircraft were for surveillance and state purposes. So it quacks like a duck. And then the object is to further well, the point is, so it looks like a duck, it swims like a duck, it quacks like a duck, but it's not a duck. I fail to understand. There's many elements to consider the point, the contrary point here that you're making. And there was a direct question by Dr. Rab on this issue. Would you like to change your answer to that question?
Mr. Arbitrator, in that sense, respondent's position is that this is a commercial contract in the sense that the ICCA would be able to apply. Nevertheless, the ICCA does not contain a provision such as Article 2 of the CISG, which does exclude aircraft. The CISG does not consider aircraft as a commercial good. Therefore, that is why the CISG does not apply to the PSA, but rather it is governed by the law of Equatoriana. Now, if I could just briefly conclude with my second issue.
Yes, go ahead.
Thank you. The CISG is also not the governing law for respondent's misrepresentation claim, but rather it is governed by Equatoriana's contract law. Members of the arbitral tribunal, the issue at hand is not one of the conformity or non-conformity of the goods. Respondent raised this claim because it felt that it had been lied to when it concluded the contract in 2020. At that time, they asked for the newest model available in the market, and claimant knowingly and openly entered that call for tender with the intention of releasing a newer model of their drones not even 3 months later. That issue is precisely an issue of validity, of whether one party was lied to with the sole intention to enter into a contract. In this sense, Article 4A expressly excludes issues of validity from the scope of the CISG.
Counsel, is
Yes.
the Kestrel lie sufficient for your purposes?
Yes,
Then, therefore, there is no misrepresentation, right?
not exactly.
Because the reason you entered into this contract is to contract for a good that serves your purpose. This good serves your purpose.
Certainly, Mr. Arbitrator. Nevertheless, respondent, when they opened the call for tender, they wanted to obtain a certain good in the market. And what claimant presented was not that, but rather when they released the Hawkeye 2020, that specific drone contains surveillance communication. In contrast with
Counsel, counsel, at best, that can be a breach of warranty, giving rise only to damages. It's not a misrepresentation for you to avoid the contract.
Mr. Arbitrator, at this stage of the arbitral proceedings, respondent submission is merely on what the law applicable to this specific issue is, not whether there was misrepresentation or not. In this sense, the law applicable to this misrepresentation claim, given that it is only an issue of validity and not one of conformity, is the ICCA in Ecuatoriana and not the CISG. If there are no further questions, that concludes my submission for the merits.
Dr. Rab, any further questions? Madam Rogers? Nothing? Okay. Thank you, counsel. So now we will go to Ms. Ananya, please, for your rebuttal on the merits.
Members of the tribunal, counsel for respondent seems to be making counterintuitive and contradictory points, not just about the point about administrative contracts, but also when they go into the legislative history of the CISG and they say that drones were around at the time that the aircraft exclusion was envisioned by the CISG drafters, and yet in the conference of the CISG drafters, there was no mention of drones to be excluded from the CISG. Neither was it an intention of the drafters, even though drones were around, according to my opposing counsel. The CISG drafters never mentioned that drones or unmanned aerial systems were intended to be considered in the category of aircraft and hence excluded. Therefore, their submission this goes against their own submission.
Thank you, counsel. Now we go with Ms. Rendon for her rebuttal.
Thank you, Mr. Arbitrator. Members of the arbitral tribunal, perhaps drones themselves are not explicitly referred to in the conferences of the UN, but neither are Boeing 787s and neither are DHL airplanes. And just for that fact, it does not mean that the CISG automatically applies. This arbitral tribunal shall find that the Kestrel I-2010 is an aircraft in the sense of the CISG. Thank you.
Thank you very much. So before we close the hearing, I will once again ask my co-arbitrators if they have any questions. Nothing? Okay, then I would ask the members of counsel for claimant if you believe you had sufficient chance to present your arguments.
Yes, Mr. Arbitrator.
Thank you. And counsel for respondent, do you believe that you had sufficient chance to present your arguments?
Yes, Mr. Chairman.
Arbitrator.
Very well. So with this, then we close this hearing, and I would ask the members of the teams, counsel for claimant and counsel for respondent, to please hold on for a minute while we deliberate. And I would ask the administrators to please put us in the breakout room. Thank you very much.